Well,
Mhm.
then we can go to get things rolling. So I guess welcome everybody to today's Investor Power Hour. For those that are joining us perhaps for the first time, this is a monthly show that we do to educate our investors, keep them abreast of kind of the best practices in the real estate and investing world in general. And usually we educate a lot of folks using a lot of the experiences that we have over here at Disrupt Equity. But oftentimes we also like to bring in experts in their respective fields, such as our guest today, Garrett and Ted Sutton, who will be taking care of today's kind of presentation and educating you on asset protection. Because as we know, once you've made it okay in life and started to gain some assets, unfortunately, there are going to be some people out there that may have an interest in trying to get those assets from you. So today we are joined by Garrett Sutton, who is a best-selling author, one of Robert Kiyosaki's Rich Dad advisors, and founder of Corporate Direct Inc. And alongside his son, Ted Sutton, an attorney, content creator, speaker, author, and junior partner at Corporate Direct Inc. and the Sutton Law Center. And Garrett Sutton has been in practice for more than 35 years, and he assists entrepreneurs and real estate investors from around the world to really protect their assets and maximize their financial goals through sound management and asset protection strategies. So, like we said, this is a critical element of the game that we play here in the investing world. So, with that, happy to pass it off to you, Garrett and Ted, to kick things off today.
Great.
Sounds
Well,
good.
thanks for having us. And I think the best place to start is with what we call the good, the bad, and the ugly for real estate investing. And I'll talk about the bad, and then Ted can talk about the ugly, and then we'll talk about the best way to take title for real estate. So, as you know, we live in a very litigious society. Every billboard now says, in a wreck, get a check. I mean, it's just there's so many lawyers out there suing over, not only car wrecks, but people who fall in grocery stores and just anywhere you look, you see litigation. And it's gotten so bad that now there's a litigation boom in Sweden. Attorneys are suing in Sweden quite a bit, and over there they call it the American disease. So that's how popular we are with regard to litigation. So knowing that we have this litigation explosion, we need to take care of how we take title to our real estate. Now, insurance is always the first line of defense. I always recommend that you have insurance when you buy your personal home. You're going to have insurance on the home. When you buy a duplex for the first time, you're going to have insurance, fire and casualty insurance for the duplex. But a lot of people think that's enough. And the insurance is only the first line of defense. We know that insurance companies have an economic incentive to not cover every claim. So they're going to try and find ways in the little tiny small print to avoid paying on a claim. Well, if title to the real estate is in your individual name, that means a tenant who falls on the property can sue you personally. And if the insurance doesn't cover you, or if it's not enough, say it's a really bad claim, they have a claim against all of your personal assets. And, spouses don't like this. So we really want to, pay attention to our spouse's needs. You're going to have that insurance and you're going to have title held in the right way. Your individual name is not a way to take title to rental real estate. There are a couple other bad ways to take title. One is joint tenancy. A lot of people hold title as joint tenancy, but if someone passes, then the interest goes to the other joint tenant. And if you have a partner in a deal, you may want that interest to go to your relatives instead of to your partner, because what happens with joint tenancy is there's a automatic right of survivorship. So your partner, Joe, and you take title as joint tenants. If you pass, title to the 100% of the property goes to your partner and not to your heirs. So joint tenancy is not a great way to take title if you're investing in real estate with a partner. So we want to avoid these methods and we want to take title in the right way. So we've talked about the bad. Now Ted's going to tell you about the ugly way to take title.
Yeah. So general partners, sole proprietorships,
That
right?
those are other ways to, yeah, go ahead and talk about those.
Yep. So there's again, Dad mentioned some of them, or my dad Garrett mentioned some of them, but the ugly ways to take title are if you operate as a sole proprietorship. So if you take title to real estate in your individual name, this can be really problematic if you have a large commercial real estate parcel, you have tenants, you have other issues, your liability risk is higher. And if it's in your individual name, when they sue, you're going to be on the hook for everything. You're going to have no liability protection whatsoever. But I would say the worst way to hold title is as a general partner. So this is where you and your business partner shake hands. You both buy a property together. You don't have any written documentation. You have no entity structure. Um, you guys just own it individually. And that could cause problems because not only do you have to deal with tenants, but things can go poorly between you and your business partner. So with a general partnership, it's the ugliest way to hold title just because you can face liability in many different ways. But however, there are, or do you want to go?
There's one more ugly way to hold title, and that is through a C corporation. Now, back in the day, they didn't have LLCs back in the day, and people did hold title to real estate through a C corporation. And the problem with that is you have the double taxation. So when you sell the real estate, the money comes into the C Corp, you pay tax at the C Corp level, which is now 21%. And then when you want to take the money out of the C Corp, you pay tax at your individual tax rate. So you're paying the double tax. So not many people would recommend taking title in a C Corp anymore. They used to. But if you talk to an advisor who suggests that you take title to real estate in a C Corp, and C is a tax provision, we have C and S Corps, which refer to tax codes. But if they suggest taking title in a C Corp, just get up and walk out because they don't know what they're doing. So we have some bad ways to hold title, some ugly ways to hold title, and then we have a couple good ways to hold title. And I'll talk about the first one, the most common one now, is the LLC, the Limited Liability Company. And we like that one because it offers two really key advantages. One is the LLC in most states has good asset protection, meaning if a tenant sues, you're only going to have to pay or lose rather what's inside the LLC. They can't get beyond the LLC to your personal assets, like if you hold title in your individual name. So that's the inside attack. The tenant sues, they can get what's inside the LLC, which means we're not going to hold 10 properties in one LLC. You've created a target-rich LLC. So the tenant sues, they can only get the one or two properties equity in that one LLC. For your third, fourth, other real estate properties, you're going to set up other LLCs. So we're going to segregate the real estate in separate LLCs. Now, the LLC also provides asset protection on the outside attack. And that's when you get in the car wreck, someone sues, they want to get at your assets. And by having a Wyoming holding LLC, holding all your other LLCs above it, they can only get what's called the charging order, which is a lien on distributions, meaning they have a judgment against you. You've been in the car wreck, they went to court, they have a judgment against you. The insurance company hasn't covered the claim. So they want to get at your other real estate holdings, but those other real estate holdings are held by one Wyoming LLC. And to get through the Wyoming LLC is very difficult. All you get, according to Wyoming state law, is what's called the charging order, meaning you stand outside the LLC and the court order is that you receive all distributions made from the LLC. Well, you may not make distributions. And attorneys who are on a contingency fee, these attorneys on the billboards that we mentioned, get a rec, in a rec, get a check, they have to wait around and monitor what comes out of the LLCs so that they can collect. They're on a contingency fee. They don't get paid until they receive money from the LLC? Well, they're better off going after the next case that has insurance monies. So you're better off. The attorney is an economic animal. They know they're better off going after the next case, the car wreck case that has insurance. They don't like waiting around trying to collect from an LLC. So the LLC has great asset protection for both the inside attack when the tenant sues and the outside attack when you're in a car wreck. The other advantage of the LLC is you have flexibility in taxation. If you're the sole owner of the LLC, it can be a disregarded entity. Everything flows through to you. If you have a partner in the properties, you can be taxed as partners. If there's a reason to be an S Corp or a C Corp, sometimes there is, you can be taxed that way too. So we have great asset protection and flexible taxation with the LLC. Now, Ted's going to tell you about the other good entity that we see being used, especially in syndications. And so real estate investors should know about this way as well.
That's right. So in most cases, you're going to use the LLC, but the other good entity that's used in some situations is the limited partnership. And so what a limited partnership is it's an entity that you set up, and it requires at minimum two different types of partners. One is the general partner who runs the show, and the other partner is the limited partner. Now, this can be really helpful because if you have a syndication, you can raise money from limited partners. So they invest a certain percentage into the deal, and their liability is limited to what they put into it. Now, with the general partner, you can own as little as 2% of it, but if anything happens on the property, the general partner is going to be responsible for all that liability. So it can be good in a lot of situations, but what we like doing is if you're a general partner, you run the limited partnership, we like setting up an LLC to hold your general partnership interest just because your liability is limited there. Now, the LP, it protects you against the inside attack where the tenant sues, just because if you're a limited partner, your liability is limited to what you put in. And then if you're the general partner, if you have an LLC that's standing in between you and your LP, that acts as a blockade for your liability protection there. Now, when it comes to the outside attack, if you're the general partner and you hold your interest in an LLC, you're going to be protected. So that's where you're personally sued. And if you have a Wyoming LLC, you're going to get the charging order protection. If you're a limited partner, it could be helpful to have a Wyoming LLC hold your interest in the limited partnership, just because, that Wyoming LLC will provide the charging order protection. And it just provides another layer of protection between your personal liability and your valuable real estate investments. So LPs are good, but when they're used in combinations with LLCs, they provide you with better protection there.
So these are the good entities that you're going to be using as you get into your real estate career. LLCs, particularly if you have one or more state holding LLCs. Let's say you have a property in Utah and a property in New York. Those are the two weakest states for asset protection in the country, along with California. But let's say you have a Utah LLC for the Utah property because you're collecting rents in Utah, you're doing business in Utah. You might as well have a Utah LLC for that property. And the same in New York. You're collecting rents in New York, you're part of the New York tax system. But those two LLCs, the Utah LLC for the Utah property, the New York LLC for the New York property, are owned by one Wyoming LLC. You only need to have one in most cases. And don't listen to the advisors that say you need 7 layers of protection. You just really need 2. So the Wyoming LLC is the one that gives you the outside attack asset protection. Again, if someone gets in a car wreck, they sue you in a business deal, they're trying to get at your assets, they need to force a claim against the Wyoming LLC, and all they get is the charging order, which means they're waiting around to get paid. And attorneys on a contingency fee really don't like this. Now, we mentioned insurance, and insurance is key here because we do want to have that first line of defense being insurance. But a lot of times, insurance companies will say, well, you're operating through an LLC. That's a business entity. We have to charge you a higher premium, which is really nonsense because the risk of a fire is the same whether title's in your name or in the LLC. So if your insurance company does this to you, what you'll do is you'll say, okay, leave the premium in my name and list my LLC as an additional insured. And so that way you get the coverage, you get the lower premium, you pay the premium with an LLC check, but the premium is in your name, but your LLC is listed as an additional insured. And that is really important here. Now, some people will get umbrella coverage for all your properties. So I always recommend you have insurance for each LLC that holds title to property, fire insurance, casualty insurance. But you can also get an umbrella policy over all your title holding LLCs. Some Here in Reno, it's pretty expensive, so we haven't done umbrella insurance for our properties. We certainly have it for our personal residence and our automobiles. That's where I think umbrella insurance really comes into play because if you get in that horrific car wreck, you want to have enough insurance to cover that claim. And an extra $1 million of umbrella insurance is only what, Ted, $400 a year.
I think with inflation, it might be at 500 or 600, but it's relative to what you're getting is pretty cheap.
It's good insurance. The attorneys know how to get at that money and they'll leave you alone on your other entities. So you always want to make sure that you have insurance on these properties. And if you hold them in an LLC, you need to make sure that the LLC is listed as an additional insured. So Ted, any other thoughts on insurance?
No, it's good to have it. Just because there are situations where people don't have it, they don't have it as their first line of defense. And then when that happens, they could be on the hook for some really big liability. So
another key issue here when you're investing in real estate and looking to protect your assets is title. So, everybody knows what title is. You go to the county recorder's office and you look up the parcel number and it says Joe Blow is the owner of 123 Main Street. All right. Now, if Joe Blow gets sued, I mean, someone can easily go to the recorder's office and see what he owns. And if he owns it in his individual name, the equity in that property is exposed to a claim. And so let's say 123 Main Street is a fourplex that's worth 500,000. And the bank has first dibs because they have a first deed of trust against the property for 200,000. That means there's $300,000 left in equity that someone suing can reach. And so they go to court, they force a sale of the property. The bank gets their first deed of trust paid first. Perhaps you have to sell the $500,000 property at a discount. So on the courthouse steps, it goes for 450,000. But the person who has the claim against you, because title is in your individual name, has been able to get $250,000. So again, holding title in your individual name is not the best. Now, because you set up an LLC, you're going to transfer title from your individual name into the name of the LLC. Too many people will set up LLCs and think they're done. No, you need to take that extra step of transferring title into the name of the LLC. And in some states, there are transfer taxes when this happens. Pennsylvania is the worst. They have a 2% transfer tax so that you take title in your individual name, and 2 weeks later, you've set up the LLC, and on $1 million property, a 2% transfer tax is 20 grand. So in that situation, you want the LLC set up first and just take title originally into the name of the LLC. Some states have exceptions. If you transfer title from your name into the LLC, that's an exemption. There's no transfer tax. But be aware of the transfer tax when you do this. But you still got to pay it. I mean, it's best to take title in the name of the LLC when you buy the property to begin with. But let's say you bought the property and in your individual name, and you're kind of listening to this seminar and you go, oh my God, I got to transfer title into an LLC. Just check with your broker and see if there are any transfer taxes. You may just have to bite the bullet and pay them because we want title to be in the name of the LLC. If it's in your name, all your assets are exposed. If it's in the name of that LLC, all that's in the LLC, the equity in that one or two properties, is all that is exposed, not your personal assets. So, Ted, any further thoughts on title?
Yeah, well, the analogy I like to use when transferring title into an LLC is like you have two glasses of water. One is in your individual name, and the second one is the name of your LLC. So, when you set up the LLC, that's like purchasing that second glass of water. But what I've seen in my short legal career is that there's a lot of people that we help that we set up the LLC for them, but they fail to take the next step to transfer title into the LLC. So when you have two glasses, one has water in it, the one with the individual name has your water. You need to pour it into the glass that has, or that's in the name of the LLC. And so that's a big step because if the title is in your individual name and a tenant sues, they're going to go after all your personal assets. So that's the next step that you need to take once your LLC is up and running.
Good. Well, let's talk about protecting your personal residence. And this is important. You bought a house, it's where your family is living, you're raising your kids in this house. It's really an important part of your life. And we want to protect it as best we can. The best way, the first way we look at protecting the equity in your house is with what's called the homestead exemption. And this started down in Texas when they were an independent republic in the 1820s. They had, seceded from Mexico, and they were an independent republic for a few years. And they wanted to get settlers down from the U.S. to help populate Texas. And they created this economic development tool called the homestead exemption. And what that means is if someone sues you later, after you take title to the property, someone sues you in Texas, they can't get the equity in your personal residence, even if you have acreage. And so this is became a very popular way to protect the equity in your personal residence. And other states followed suit. Florida has an unlimited homestead. California used to have a low one, but they've raised it. It's around 600,000 a year. So's Nevada. Some states, Pennsylvania doesn't even have a homestead. So it varies state to state, and all the information is on the internet. But what you're going to do for your primary residence is you're going to consider taking title and putting the homestead on it. And then if your state doesn't cover you enough, let's say you're in a state that has a homestead of like $10,000, I think that's Kentucky, and your property's worth $1 million, well, the homestead really doesn't protect you there. So then you would look at putting your property, the title to your home, into a Kentucky LLC where you would have better protection. Again, you're going to have insurance on the property, perhaps an umbrella policy. But the first way to look at protecting the equity in your house is with the homestead. And then absent that, if there's not enough room to protect you, or like Pennsylvania, there's no homestead, you'll look at taking title perhaps in an LLC. So, and one other thing, you only get one homestead, per person. So if you have a property in Florida where it's unlimited and another property where you also live in South Carolina, you would probably use the Florida homestead to protect all the equity in that one residence. So Ted, any other thoughts?
I think ultimately it depends upon what state you're in and how much home equity you have. We live in Nevada. The homestead exemption here is really high. It's about $580,000. So for me, my house is right in that range. I have a homestead on it. But if you live in a state like Virginia or Pennsylvania or New Jersey or Kentucky, and you have a house that's worth millions of dollars, the homestead exemption filing is not going to do you any good. So in that case, it may make sense to have an LLC.
Great. Another key topic when it comes to asset protection is the corporate formalities. And this is the most overlooked area of corporate law. And the corporate formalities are a requirement that when you set up this LLC for asset protection, you've got to follow these continuing formalities to stay protected. And what happens is people don't follow the formalities. They forget to do their annual minutes. They don't pay the fee to the state, which you lose your charter. You have no asset protection there. They combine their personal and business bank account. They commingle funds between personal and business bank accounts. And when you engage in these kind of sloppy behaviors, someone can come in and say, Your Honor, I have a judgment against this LLC, but they haven't followed the formalities. They haven't acted like a regular LLC, and it applies to corporations as well. And the court can look at the factors and say, you know what, you're right. They haven't followed the formalities. We're going to allow you to pierce through the corporation or the LLC and reach the personal assets of the person who owned the LLC. And so you've done all this work to set up the LLC, but by not following these formalities, they can pierce through the LLC and get at your personal assets. And this happens in almost 50% of the cases, which means a lot of people aren't following these easy corporate formalities. So I wrote a whole book on it called Fail Not Fail. It's that big a topic, the piercing of the corporate veil. So Ted, what are your thoughts? What are some of the overlooked corporate formalities that get people in trouble?
Yeah, so the analogy I like to use to describe the corporate formalities is that you just have to treat everything separate. It's like two separate buckets. Whenever you have a rental property, you hold title to an LLC, you need to make sure that you have a separate business bucket for that, separate and apart from your personal affairs. I think there's there's probably a few dozen corporate formalities, but the biggest one that I see is that there's a lot of people out there who just set up an LLC and they don't set up a separate business bank account for their LLC. So, when you set up an LLC, you'll get filed with the Secretary of State. You'll get an EIN number from the IRS, which is your LLC's Social Security number. And what you'll do is you'll take that to the bank to set up a separate business bank account for your LLC. So having a separate bank account's one of them. Another thing is just making sure that you're in good standing with the Secretary of State. There's a lot of people out there who just set up their LLC once and then forget about doing anything about it in the future. And one of those things is making sure that you're paying your annual filing fees with the Secretary of State. And it's interesting because in that lawsuit I helped your friend with, the defendant was an LLC, but they were in bad standing with the Nevada Secretary of State. So because of that, I got to sue the owner of that LLC in their individual capacity. So, just looking at it from the offensive side, if you aren't following the corporate formalities, it's really easy to pierce the corporate veil. But, we act on defense. We want to make sure that if you have real estate or a business or anything of the like, you need to make sure that you're treating everything separately. And if you are, then that veil of protection will be really strong and it'd be really hard to pierce the corporate veil.
So another key element here is the registered agent or resident agent. And this is important. A lot of people overlook this formality as well. And when you set up the LLC in Wyoming, for example, you have to have an agent in Wyoming to accept service of process, meaning government notices and notices of lawsuits. So we have a whole office in Casper, Wyoming, great little town, where we serve as the registered agent for all these Wyoming entities. Now, if you don't pay your registered agent, they can withdraw, and then you have no representation in the state of Wyoming. And this is true for all 50 states. Now, if you don't have a registered agent in Wyoming, someone suing you is going to go to the registered agent's old office and you'll say, well, I'm sorry, we had to withdraw, they didn't pay. And so the person serving you the notice of the lawsuit can go back to the court and say, we tried to serve process, and the company withdrew. Or if you are your own registered agent and you're not around, if you use your home address, we never like people using their home address because a registered, someone serving process can come by and you're at work or you're traveling. And so they can't get the notice of the lawsuit to you. And you want notice of the lawsuit so you can turn it over to your insurance company. You want notice as soon as possible. So, for example, in our office in Casper, Wyoming, when someone gets sued, we're on the line to you immediately. We're letting you know in 10 minutes that you've been sued. But if you don't have the proper registered agent, what can happen is the person trying to sue you goes to the court where the claim was filed and says to the court, look, we tried to serve the registered agent. They withdrew, or the person wasn't home. It was their home address. And so the court says, okay, well, then you can publish notice in the newspaper of the lawsuit. And these are the legal notices in the back of the newspaper. They're in a tiny 2-point type, and no one ever reads those. And so you file, put out the legal notice, and of course, you're not going to see that. So then the person goes back to the court and says, okay, we tried to serve the registered agent. They withdrew. We published notice in the newspaper and no one responded. We would like a default judgment. And that means you've lost. When the court says, okay, you tried to serve them, they didn't respond, we're going to give you a default judgment, that means you've lost the case. And insurance companies aren't going to cover you in that situation. You didn't do the proper thing. You didn't have a registered agent. You didn't respond to the complaint in time. The insurance companies have grounds not to cover you. So the registered agent is really important, and you don't want to do it from home. You don't want to have a mom and pop registered agent service that's going to close their doors and leave you hanging. You want to use a service that's been around. Like we've been around for over 30 years doing this. So it's important, and one of the biggest corporate formalities is to have that registered agent. So, Ted, any thoughts on that?
Yeah, well, having a registered agent's key just because it's one of the corporate formalities. Another thing is that if you have a holding company in a place like Wyoming or Nevada or Delaware, and you don't live there, you're going to need to list a registered agent address in that state anyway. Another thing is that it's good for privacy because there's a lot of people who use their home address as their registered agent. That information is publicly available. And the issue is that process servers operate between 8 a.m. and 5 p.m. Monday through Friday. And there's, during those times, there's a good chance that you're going to be gone. I mean, unless you work from home. But
I have a horror story. I have a client that lived in Maryland and used their home address as their registered agent address for a Missouri entity. So the Missouri entity owned a trailer park. The Missouri entity was owned by a Wyoming entity, and they used their Missouri address for the Missouri trailer park. I'm sorry, used their Maryland address. And the people in the park went online and on Google Maps saw how valuable the house was in Maryland that the owner of the trailer park owed. In fact, they put a picture up in the trailer park saying, this is where the owner of the trailer park lives. You don't have to pay rent. And so you really don't want your personal address out there because there are tenants looking for every excuse not to pay. And in this case, it created a real problem for this owner because, in this kind of low-end trailer park, these people felt like they didn't have to pay because the owner was rich. It's unfortunate, but that bug is out there now, that if the owner's rich, you don't have to pay. So let's talk about one other strategy, which is called equity stripping. And Ted, why don't you go into equity stripping?
yeah, so what equity stripping is it's a way to strip equity away from your rental properties. So, this comes into play when you have a lot of equity exposed, whether the note's been paid off or you buy a property with cash. Now, the whole purpose of the equity stripping strategy is that your property appears to be more encumbered than it is to creditors. So if somebody were to sue the property, they would see that there's a deed of trust on the property for a certain amount. And, with that, that equity is, it appears to not be exposed. So what we like doing is we like having one LLC that holds title to the rental property, or the commercial building or whatever else. And then you have a second LLC that we like setting up in Wyoming. And the whole purpose of that LLC is that it strips equity away from your rental properties. So what would happen in this arrangement is that you have the second Wyoming LLC, which extends a line of credit to the first LLC that holds title to your rental property. And it's kind of like a HELOC. You're free to use as much or as little of it as you choose. Then in exchange for that line of credit, the rental property LLC exchanges a deed of trust back to the Wyoming LLC. And so if you have a rental property that's worth $1 million, the Wyoming LLC can extend a line of credit for $1 million, and then you give it a deed of trust in exchange. Now, as I mentioned before, this is big because if a tenant sues and they see that there's a deed of trust worth $1 million, your property appears to be more encumbered and they're going to be more likely to settle. Now, the thing is if you ever go into court, you lose, you have a debtor's exam, you're going to need to tell the truth and say that it's a line of credit arrangement.
Or you tap the line of credit.
Or you do that.
But like Ted says, you got to tell the truth. When you're in court in front of a judge, you are telling the truth. There's problems. It's called perjury. When you don't tell the truth in front of a courtroom, you can go to jail. And I know a lot of people in Congress commit perjury and nothing happens to them, but you and I have to hold up this system, and you have to tell the truth when you go to court. So just know that.
Yeah.
So equity stripping is a popular strategy. And, Robert Kiyosaki insists that I always hold up a book once a seminar. So this is my book, Loopholes of Real Estate. And it's a great practical guide for investing in real estate. We have a whole chapter on equity stripping in this book. So I highly recommend it. So
yep.
What else, Ted?
So I don't know if we're going to have a Q&A. I think that could be helpful, but there's one other thing that I want to cover that's going to be new and on the horizon. So I'm sure a lot of you know about the Corporate Transparency Act. It's that federal law that requires people to report information to the federal government. Since Trump took office, that's on pause. But what I should tell you is that other states are enacting their own transparency laws, one of which is New York. They passed a law that's called the New York LLC Transparency Act. And so what you're going to have to do is you're going to have to report similar information to the New York Department of State. It's something that isn't being talked about right now, but it takes effect on January 1st. So if you guys have any commercial real estate holdings in New York, you hold them in LLCs, you're going to be subject to that new law. Another thing is that other dominoes could fall. I mean, you could see states like California pass similar laws. I think Maryland and Colorado are potential ones too. But if you're in the commercial real estate space, this is something to be on the lookout for because, it's going to have wide sweeping consequences. And
it's interesting, the Federal Corporate Transparency Act was for corporations, LLCs, LPs. The New York one is just for LLCs.
Just for LLCs. So if you have a corporation, a limited partnership, it doesn't apply to you. So, all the criminals may use corporations in New York for all we know. So, but yeah, it's an interesting development, and I just wanted to share it with you guys because this is just a new corporate law that's on the horizon. And so if you're in New York, it's going to affect you, but other states could follow suit in the next few years. So I think it's important to just be aware of that.
So do we have any questions that we can answer for the viewers?
Garrett, definitely appreciate you putting that on. For everyone on the call, there is a Q&A button actually on your screen at the bottom of your Zoom window. If you have any questions, go ahead and enter them there, and we should be able to go ahead and address them. And I guess in the meantime, while those come in, I do have a couple questions that have come up that I've heard as well with our investors and so on. One thing that maybe would be helpful is if you can add just maybe at a high level, even the usage of these LLCs versus a trust versus a will. Kind of maybe tell us about how you think about that.
Okay.
Yeah, so my dad talked about how there's two levels of protection. I mean, if you include trust and estate planning, it's really three. So you have one LLC that holds title to your rental property. That protects from the inside attack where a tenant on that property sues. Then what you do is you set up a Wyoming LLC on top that owns your interest in the rental property LLC. That protects you against the outside attack. So that's where you're personally sued and you have the charging order protection through Wyoming. Then where trusts and wills come in is usually the trust owns your interest in the Wyoming LLC. So, I mean, having a will can be good just because you get to distribute your assets accordingly after your death. But the thing with wills is that you don't avoid the probate process. So, if you die with a will, you still need to go into probate court, and that probate judge would have to administer your estate or, get a decree to determine how things are passed. So instead of a will, we like, in a lot of situations, setting up a revocable living trust that owns your interest in the Wyoming LLC and then everything else indirectly beneath that. So really there's three layers there. You have the LLC for the inside attack, the holding company for the outside, and then a revocable living trust, just because with the trust you avoid probate.
But it's important to know, and there are a lot of promoters out there that will say a living trust offers asset protection, and that is completely false. The revocable living trust, if you have title to your duplex in the name of the living trust, then someone sues and you go into court and the court says, okay, well, transfer the asset over. The living trust offers no asset protection. So please beware of promoters that want to get you into a living trust saying that it offers asset protection. It does not. It does avoid probate. It's very useful. So the LLCs and the living trust work together. One gives you the probate avoidance, the living trust. One gives you the asset protection, the LLC. But you need both to really make things work together.
Mm-hmm. Yeah, and just a quick point there is that I have dealt with clients in the past where they've held title to their rental properties in a revocable living trust. And there was one person I was speaking to, they ended up killing a pedestrian, and their assets were held in a revocable living trust. And it was just completely gut-wrenching to hear that. But I had to tell them, unfortunately, you don't have any asset protection in that situation. So, it's important to just have the structure ahead of time, LLCs for the attacks, and then a revocable living trust to avoid probate and distribute your assets accordingly. And with that, with those three things, you should be good to go.
Great. Thanks, guys. Maybe you touched on another point too, which is revocable versus irrevocable trust. Kind of what's the thoughts around those?
Yep. So revocables are trusts that you can make changes to. So this is where you could set it up. And with that, you have a plan to pass your assets on to designated beneficiaries. And, let's say you have a falling out with one of your kids or another family member. With the revocable trust, you can make changes in the future. Usually they're updated every 5 or 10 years. With an irrevocable trust, it's a trust that once you set up, it's very, very hard to make changes to. Usually the grantor, the person setting it up, and all the beneficiaries have to agree to make changes to it. And we just saw that here recently with Rupert Murdoch. His court case was just down the
It was
street.
3 blocks away. Rupert
Yeah.
Murdoch's driving up in limos and his kids, and he wanted to have one son be in charge of the Fox News empire, and the other two didn't want it. It was an irrevocable trust. And the court said, I'm sorry, you can't change it. It's irrevocable.
Yeah.
So be really careful getting in with an irrevocable trust. That said, they do provide asset protection, but they are expensive. There's, $10,000, and then you got to pay a trustee $2,000 a year for it or more. And so for most people, the LLC structure with the Wyoming holding entity is plenty fine.
Got it. Okay. I don't see any additional questions coming in, but you've actually brought something to mind that I know someone else kind of dealing with this, which is kind of an interesting question. And this is a case in Texas. So someone I know, they basically had a civil suit in Texas and they had a judgment against somebody. Okay. For a significant amount of money. The losing party, they had a house that was a primary residence in the past, but they have since moved actually out of the country, but they've kept that house uh, as a rental now. So can that winning party get to that house, or is that not really possible?
Well, did they have a homestead on it?
I imagine they did.
If they did, but they're not living there, if they could go into court and prove that this was now a rental property, that it was not your primary residence, but now you were renting it out, that doesn't qualify for the homestead. Hopefully, when they turned it into a rental, they placed title into the name of a Texas LLC. Texas has gotten really good. They're competing with Nevada, Wyoming, and Delaware to be a good state. And Ted is licensed in Texas, so that's valuable. But in that situation that you described, if they are living overseas and they do not have a protective entity holding title to that property, they could lose it.
Got it. Awesome. Really, really, really interesting stuff. Love this. All right, guys. Well, I think those are all the questions that we have right
We
now.
have
Actually,
one that
let's take
came in
one
from
more.
Agatha.
Yeah,
Here we go. Yeah, Agatha. Great friends for us.
yes.
Great friend of ours. So, yeah, can Garrett and Ted represent anyone in any state to set up these protections?
So for LLCs, yes. The reason being is that, when you set up an LLC, you don't necessarily need to be licensed there. It's like a paralegal service. And corporate direct, we set up entities in all 50 states. So, the LLC stuff we can help you with. When it comes to the revocable living trust, that's something where an attorney has to be licensed in that state. But yeah, with LLCs, we can help anyone anywhere across the country.
Well, and Ted's licensed in 3 states, Nevada, Wyoming, and Texas. And I'm licensed in California and Nevada. So we got 4 states covered. But for the corporations and the LLCs, yes, we can help anyone across the country.
Perfect. Thanks, guys. Then I think that is the last question that we have right now. So with that, let's be sure to tell people how they can get in touch with you guys.
Yeah, we offer a free 15-minute consultation with an incorporating specialist. So you can go to corporatedirect.com. You can call 800-600-1760, and we would be happy to assist you. We get on the line, and for 15 minutes, we talk through what you need. We find out what your needs are and how we can help. And then hopefully you're going to use our services. We don't use AI. We too many people are using AI now, and they don't know what they're getting into. So we offer a great deal of customer service. We're unique in the sense that when you call us, we answer the phone. So you're not getting a recording. So we'd be happy to work with anyone out there to assist them in structuring their real estate activities properly.
Yep. And I
Perfect.
actually copied and pasted our website link into the chat. So, just to make things easier, you could just click on that link and it takes you to our brand new website homepage. So we have lots of resources there that you can look through. And, if you want to schedule a free 15-minute consultation, you can do that as well.
Great. Thanks, guys. I love the comment about AI. I know there's the lawsuit that took place recently with a gentleman. The attorney basically used AI to cite sources that didn't really exist. So he's
Right.
since been punished. But yeah, it's interesting to see how this kind of whole world is evolving with the usage of AI.
Yeah.
But
Yeah, I mean, it could be a tool that you can use for some things. Like, I make YouTube videos once a week. It helps generate the script and I double check for accuracy. So I think for that it can be good, but you can't just absolve all brain power to AI. I mean, I've seen people who just, draft an operating agreement with Chat GPT and all these other things. So yeah,
sure, still
interesting
gotta think.
stuff. Yeah.
Awesome, guys. Well, Garrett, Ted, definitely appreciate the time. Appreciate all the valuable information. Again, everybody on the call, if you'd like to get in touch with them, it's corporatedirect.com. It is in the chat window of Zoom. So if you have any questions there, Agatha, I can reach out to you directly with their information as well to make sure that you get that. So I'll reach out to you after this call. But anyone else, please uh, visit them if you have any questions. And in the meantime, appreciate everybody joining us for another Investor Power Hour here at District Equity. If you have any questions that you want to reach out to me or to Garrett and Ted, if you can't get a hold of them, please reach out to us at invest@districtequity.com or Tarek@districtequity.com. You'll get to the same place, and we'll be able to get you taken care of. So appreciate you guys joining us today, and look forward to having you join us for next month's Investor Power Hour. Thanks, Garrett. Thanks, Ted. Thanks,
You
guys.
guys.
Yeah,
Bye.
thanks,
Bye-bye.
Derek.